the big story today is that the Supreme Court has put its own verdict in abeyance. Remember, viewers, on November 20th, the Supreme Court, through its 3-judge bench, led by the then Chief Justice, authored a verdict on Aravalli, bringing in a rule that anything below 100 meters is not Aravalli range mountain. A very strange order which would damage forever the ecology of the Aravalli mountain range, a 2 billion year old formation. But what the Supreme Court did between 20th and today's judgment is the result only of public opinion. I would like to start by thanking the Supreme Court for putting its own November 20th order in abeyance till further study. But even more than the Supreme Court, I would like to thank you. I would like to thank the people of India. I would like to thank the viewers of Republic. I would like to thank the 1.5 billion population of this country, ladies and gentlemen, for coming together as one and reminding everyone that there will be no asymmetry of power in this country, that the power is with the people. That's why we say here at Republic, power to the people. Now, ladies and gentlemen, the important thing is to acknowledge is for everyone, whether government, Supreme Court, institutions, systems, state government, central government, lawyers, legal fraternity, and everyone to recognize that this decision of the Supreme Court to keep its own order in abeyance is an extraordinary decision. It does not happen ever so often. And the only reason it has happened is because the virality of the public campaign, the strength and conviction of the Republic Media Network, and the belief of the people that matters of ecology and matters of public interest have to have a strong level of media advocacy backing it. This is the only reason the Supreme Court has put its order in abeyance. Remember, they have not reversed it. They've only put it in abeyance. But it is also an acknowledgement that campaign journalism, activist campaign journalism, which is done with conviction on the ground, joined with very deep, very well thought out, investigative reporting, and then the conviction of an editorial team and independent journalism, has all come together to create such public pressure on the system that there is an acknowledgement today that beyond everything, beyond executive, legislature, judiciary, there is, most importantly, ladies and gentlemen, the court of public opinion. And we serve in the courts of public opinion. We are not the determinants. People say judge, jury, executioner. That's completely wrong. We are equal members of the courts of public opinion, and our job and our commitment is to drive public opinion in the direction that it can make a change. Today, I bow down to the strength of the people, the Republic Media Network. Their conviction has made the Supreme Court review its own judgment. Some have asked me, Arnab, were you trying to get an upper hand on the Chief Justice of India, Justice Gawai, when you interviewed him? No. But I was asking the former Chief Justice for clarity in ambiguities over his own judgment. And today, the Supreme Court has also asked for clarity in ambiguities over their own judgment. However, there are questions to be asked. I have 5 questions that I would like the Supreme Court, now that it has thrown things open, to ask. And my questions are for the Honorable Supreme Court. I hope they ask them. I'm sure Chief Justice of India, Justice Suryakant, will ask these questions. The first question that the people are asking is, one, the questionable timing of the judgment of Justice Gawai. The Supreme Court delivered that judgment accepting the revised definition of the Aravalli Hills just 3 days before the former CJI B.R. Gawai retired from his position. Now, in such an important matter, I believe that we must not correct later, we must correct when we can. Otherwise, this retrospective action is not required. So, first is the timing of the judgment. Secondly, precautionary principle, acknowledging but not applying the precautionary principle. Viewers, if you would see our analysis, our research and our questioning, you would see that we raise the question of the precautionary principle when it comes to matters of ecology. And today in para 8, the Supreme Court refers to the precautionary principle, saying these cumulative obligations in international law require that a uniform and streamlined approach be taken towards the preservation and restoration of the Aravali ecosystem, including regulation of the exploitation of the Aravali hills in a scientific and sustainable manner, guided by the precautionary principle. However, para 51 of the judgment stated, we accept the recommendations made by the committee with regard to the definition of the Aravali hills and ranges given by the Ministry of Environment and Forest. This reversed precaution, harm is allowed first, assessment deferred later, contrary to settled environmental law. Settled environmental law leans towards the precautionary principle. This was not unfortunately seen by Justice Gawai. Precedent was not looked at. Abundant caution, in my view, was not applied. Now, these are not good things. Everyone, the government must know, the judges must know, the legal fraternity must know that people today are very aware, and the media is very questioning, not interrogative. Now, this can be caricatured as loud. It's not loud. Very questioning, well researched and aware, and more importantly, extremely confident about speaking up for the right thing. This abdication of the precautionary principle in the previous judgment, the near abdication, is something which the courts must not allow in the future. The third point I want to make is that the courts must also see the unseemly haste, what I call a license rush. A license rush, viewers. And I would like to elaborate a little bit on it. On 20th of November 2025, Justice Gawai delivers a judgment, redefines the Aravali hills. Between 2nd of December and 18th of December, reportedly at least 58 mining licenses are auctioned in the Aravali districts according to sources. Now, the nation wants to know, were 50 given, 58 given or 100 mining licenses given? Why was there a license granting rush? We were here questioning the judgment, questioning what is going on, talking about the environmental impact. Activists were getting into the matter. At that point of time, was there a post-judgment license rush? What is today, therefore, we ask, the legal status of the licenses allegedly issued between late November to the present? Should the alleged December auctions also fall within the court's review? Will those be cancelled? The nation wants to know. The fourth point. I believe that the Supreme Court is not speaking enough about the ongoing illegal mining which has been exposed by Republic. These issues, and I have raised today, whistleblowers are being targeted, big cement companies are threatening people. Why has the Supreme Court bench not taken cognizance of the ongoing violation of mining laws? Our Republic investigation covered multiple locations including Kotputli, Alwar, Lalawandi, Sikar and even in the districts in Haryana. Not a single word was spoken against the post-sunset mining, the nighttime mining, rampant violation, not a single mention of the misuse of licenses, violation of NGT orders and DGMS norms. Why is this the case? Should this also not be a matter of public scrutiny? And lastly, ladies and gentlemen, I have something to say about this word that the courts unfortunately have used very, very sweepingly. Media trial. Today, with the greatest of humility, media trial, as the court says, would not be required, I would tell the courts, if the law enforcement agencies and the institutions didn't force people to raise it. It is very easy to cast this aspersion that serious questions, strong reporting, public interest reporting and campaign journalism is a media trial. And therefore, the question should be, why are other networks not doing what the courts call a media trial? These are not media trials. In my 29 years in journalism, I have raised several questions. Many of the campaigns I have done have served as the foundation for litigation and served also in several judgments given over the years. It is easy to classify and try and put everything together as a media trial. The court should know the Commonwealth Games scam expose was not a media trial, it was impact journalism. The court should be aware that the Right to Pray campaigns, which were picked up later by the courts, required activist campaign journalism, whether in the case of Shani Shignapur, Haji Ali or Sabrimala Shrine. It is not media trial, it is not sensational journalism, it is hardcore journalism, and the courts should also be aware, and I am sure they are aware, that in 2012, when the Nirbhaya case shocked the conscience of the nation, it was because the media picked it up in an activist campaign manner. When we raise issues of VVIP racism, in fact, we believe that judges also should not have lal battis. It is not media trial, it is campaign-based journalism. When we campaign against Brij Bhushan, against people who are recruiting for the ISIS, against people responsible for the Morbi bridge collapse, and when we question why the Maharashtra government was quiet in the case of Palghar, when sadhus were killed openly and lynched, or when we ran the biggest campaign in the country, which I am very proud of, to get to the nub of the Sushant Singh Rajput case, why the police was in a hurry to label this as suicide. These are not media trials, neither is Sengar a media trial, nor is the Adarsh case a media trial, nor is the Aravalli a media trial, nor is IPL1, IPL2 scam, in which both consequently in different occasions, once Shashi Tharoor had to quit, another occasion Lalit Modi was exposed, or N. Srinivasan we took on. These are not media trials, these are strong campaign-based issues. Journalism which has brought the truth out, told people the difference between right and wrong. And I am fully cognizant and aware that there are various people who would be uncomfortable with a media network speaking so strongly for the people. To them, I would say we will continue to do it regardless. To the honorable courts, I would request the courts to commend the media, at least those media who are raising issues on behalf of the people. After all, this is all a system of checks and balances that our democracy equips us with. Democracy has given us the tools. If Republic is using those tools to fight for the people, I think it's not a media trial, it is service to the nation. Ladies and gentlemen, once again, with the deepest of gratitude to each one of you who supported us in the Aravali campaign and who are asking us, Arnab, is Aravali a one-off? Is your asking questions for what Indigo did, its abuse of the system, a one-off? For those people who are asking us tonight that when you raise questions against Sengar, is that a one-off? Ladies and gentlemen, you've known me for a longer time. The only thing that sustains is public interest. Public interest is national interest.